Mauna Kea Anaina Hose at document 94 and document 95. And the oppositions are at 138 by UHH, 147, 137 opposition by UHH, 148 by TIO, 170, which is a joinder by Pu'eo. And as to 95, it's 138 in opposition by UHH, 147 in opposition by TIO, 153 in opposition by Pu'eo, 157 in opposition by Mr. Louis for the Attorney General. So let's deal with number 94 first. Mr. Waterman.
Thank you for the opportunity to be heard. I think I'd like to start off with this. I think, and it goes to the problems that I'm having and that I'm also raising in my subsequent motion, is that the issues of, and I understand that you do rule on certain things and the board beyond your control does what the board does. But the underlying problem with this process is that the Attorney General's office is running between the board and then coming to hearings with you, Judge. And they're the ones who are actually dictating the process when they're in a clear conflict. And so while it may not at all be you that's involved, it certainly is advisors who are sitting in this room that are advising the board on how to act, advising when needed, Your Honor, on certain issues, on whatever advice is provided. And that's really an underlying problem in all of this. And I'd like to note that after the last hearing, when we were objecting to TMT International Observatory being brought in as a party because of the premature issue about the validity of the sublease that Judge Nakamura of the Third Circuit ruled on, shortly thereafter, all of a sudden, Suzanne Case writes to one of my clients who's represented by other counsel on that particular issue, Mr. Flores, and copies Deputy Attorney General China, which would suggest that advice to proceed as such is being included with her or provided by her. And so that was sent out subsequent. That matter's still pending. Your Honor had made a ruling on that, and now the board seems to be taking up the underlying issue on the validity of the sublease, which really is what brings TIO into this room. But with that said, Mr.
Waterman, can I ask you if you believe the validity of the sublease is part or going to be an issue in this contested case hearing?
As to whether TIO should be a party or not, yes.
No, not as to party. I'm asking about the issue of the validity of the sublease.
Well, with whatever evidence they present, yes, because they should not be parties before you without that determination of the validity of the sublease being made first.
I've already made a determination on the issue of party and standing. I relied on the rule, which is very clear. There are mandatory parties and there are discretionary parties. And in my minute order, I indicated why I decided that TIO would be a discretionary party. Also, I found that they had a substantial interest in this issue. And so it's there for the record. You already made your arguments. My single question is really, is the issue of the validity of the sublease going to be part of it, going to be an issue that we have to deal with in this contested case hearing?
It may very well be. I haven't thought through thoroughly the issue and presenting it other than what I just stated to you, but it could very well be the case. The substantial interest that you talk about, Judge, really goes to also the crux of doc number 94, the motion. And and as I talked about in there, the distinction, the clear distinction of the two separate entities, both TMT International Observatory LLC, which was later formed in 2014, and the TMT Observatory Corp., which TMT International's own counsel admitted were separate and distinct entities at the last hearing. So given the fact that the application for a CDUP is being brought on behalf of another corporation, the TMT Observatory Corporation. I mean, that is very critical, I believe, in this matter, because what needs to be done is that and what I'm requesting is, and also the issue of, you know, who really is the University of Hawaii entity that's before us? I mean, we have University of Hawaii at Hilo. You know, it's a branch campus of in the University of Hawaii system. But the University of Hawaii holds the general lease. The University of Hawaii holds the general lease, not UH Hilo, not the branch campus. And I'll take this out of order. The signature required is the government entity. The landowner includes a government entity, essentially in control of the management control over the parcel is what the rule says. UH Hilo is not that entity, and they're the ones who signed the application. It should have been at the time Marcy Greenwood, who was the president of the University of Hawaii system, on behalf of I don't even know what to call them, the entity that was bringing on behalf of TMT Observatory Corporation the application. That wasn't signed by the president, and in their own admission, when they entered into the sublease with TMT International Observatory in 2014, while the UH Hilo's chancellor's signature also appeared on that sublease. The sublease was signed by President David Lassner of the University of Hawaii, clearly because he is the authority to sign documents like a sublease on behalf of the University of Hawaii system. Now, why did Marcy Greenwood not sign the application? There's absolutely no justification for that. They didn't meet the rules, and that's point one. Point two is going back to on behalf of. They're bringing on behalf of TMT Observatory Corporation, not TMT International Observatory LLC, which claims to have, and Your Honor so found, a substantial interest. This is a completely different entity. And they're not here. What suggested in some of the opposition pleadings are that, well, it's a ministerial task, we can just transfer it at our discretion. That's not allowed for anywhere. That's not provided for in the rules. And what it also does is it undermines the whole process of the public having a right to be heard in public hearings after the application is being filed, The board sets a public hearing before contested case requests are made. And at that public hearing, the public has a right to not only discuss the issues involving the proposed development, but also the parties that are involved. And that opportunity was not provided because at that time, TMT International Observatory, which again, through their own admissions, they now have this construction agreement with the University of Hawaii. They have the sublease with the University of Hawaii, whereas TMT Observatory Corporation, the entity that's supposed to be getting this CDUP. The remedy is to strike this application and to have them, just like Mr. Sankin in filing his, with all due respect to you, Mr. Sinkin, just like having Mr. Sinkin file on a certain date and all the parties file on a certain date, there are rules that have to be followed. And these rules are not being followed by the University of Hawaii or University of Hawaii Hilo or whatever the entity is that's before us. It's frankly very unclear. And the remedy is, and it's not any prejudice to them, the remedy is to strike the application and to have them resubmit the way the rules require, resubmit the proper application to the board with all of their supplemental filings and follow the process. Under TMT International Observatory LLC, which is this party with this substantial interest, the University of Hawaii, with an application signed by David Lassner. I mean, these are the rules that can't be circumvented. Rules are made to be followed. And the remedy is we submit to you, Judge, is to have the application struck and to have them do it right and to resubmit and start the whole process again. Thank you.
UHH, document number 137 in opposition.
Good morning, Ian Sanderson appearing on behalf of the University of Hawaii. We stand on our pleadings. Would like to emphasize a couple of points. First of all, we stand on our pleadings and would like to emphasize a couple of points. First of all, the University of Hawaii properly followed its own procedures in delegating and authorizing the chancellor at UHH Hilo to sign the Conservation District use application. All of that procedure is documented in the exhibits attached to our opposition. Secondly, we note that Chair Thielen signed the application as requested on behalf of the Land Board. Finally, we note that the application contemplated the future partnership that would be created that resulted in TIO with the joining of Japan, India, and China. Thank you.
Please address Mr. Waterman's concerns that there is a new entity on board and how that impacts the existing application.
You'll note in the application itself that a new entity was contemplated and that that entity is the 30-meter Telescope International Observatory Corporation, which is the successor to the TMT Observatory Corporation. And the application, if I can find it, contemplated that partnership would continue and that the entities that currently make up TIO would be the the project going forward.
TIO in opposition at 148.
Douglas Ng, appearing on behalf of TIO. I am also the attorney for the TMT Observatory, 30-meter telescope observatory corporation. So let me explain something, how the change evolved. Now, this was all disclosed in the documents, whether you look at the EIS or whether you look at the Conservation District use application. The effort began with the 30-meter telescope Observatory Corporation. That was comprised of the University of California systems, or the regents of the University of California, as they are legally known, and Caltech University. So those are the two primary members of TMT 30-meter telescope Observatory Corporation. It was a not-for-profit corporation. The governing documents of the 30-meter telescope Observatory Corporation, or I'll just call them TMT for short, allowed for certain associate partners, which included the governments of Japan, India, China, and Canada. And they were observers and attended board meetings. They all contemplated forming another entity to take over the project from TMT, simply because TMT did not have the funds to complete the project. These were interested parties who were interested in astronomy and utilizing the astronomy facilities at Mauna Kea. Now, once the Conservation District use permit was obtained by the TMT entity, TIO was quickly formed, as had been contemplated and disclosed, and TIO consists of, not surprisingly, University of California, Caltech University, governments of India, governments of China, governments of Japan, and government of Canada, all who were participants as associate partners previously. Now, is it the same entity? No, because one was a not-for-profit U.S. entity, and TIO became an international collaboration amongst certain American universities and the governments of Canada, China, Japan, and India. So that's sort of how this situation evolved. Now, Mr. Werdeman makes a lot of the fact that, well, that's not addressed in any of the rules. Well, there are a lot of things that are not addressed in the rules, but he can't point to a single rule that we violated. He cites absolutely no law for the proposition that simply because TIO came in and substituted for TMT, that the application should be refiled and we start from day one again. He cites no law, no case, and he has none. Now, as the court is, or sorry, the judge is probably aware, okay, whether it's applications, permits, permittees, even in matters before the civil courts, once a complaint is filed in the civil court or an application filed before an administrative agency, if there's a change in the name of the applicant or the applicant itself, you simply note the change. You don't go back and refile. You change a party defendant because they sold their interest in their company. You don't refile the complaint, adding the new name, you just substitute the party. That's it. It's a simple process, Judge. Let's not make a mountain out of a molehill. Thank you.
Document number 170, Pueo in support, Joinder in opposition,
For the record, Lincoln Ashita representing Pueo. Nothing further, Your Honor. Thank you.
Going next to Mr. Werdeman's document number 95. Mr. Werdeman.
Thank you, Judge. Your administrative aid kindly provided all of us with the printouts of the various documents earlier this morning that have been filed in this case. And what I find very troubling, and I then started to look at not only the rules on filing of motions 13-134 of the administrative rules, which requires service on parties with pleadings, but also in Your Honor's own July 21st, 2016 minute order number 13 filed on that date. On page 7, Judge, you made it specifically clear that in addition, copies of the filing submissions shall be sent to all other parties. And as we know, service is not only a due process issue, but it's also a professional ethics issue. And I learned this morning, and I found it interesting that Mr. Louis attended today's hearing, that he submitted a pleading on behalf, looks like Doc 157, on behalf of the various attorney generals individually here today, the Attorney General, and I think he stated when he appeared before you earlier, the Department of the Attorney General. And I will represent to you, Judge, that I have not been served with such a pleading. To my own motion, which I find inexcusable, especially coming from a former Attorney General of the state of Hawaii. I don't know what the intent was for not serving me with this so that I could come before you prepared to argue this very critical motion in this process. What the Supreme Court made clear on remand, and what the Supreme Court admonished through their published opinion was the issue of fundamental fairness and impartiality and due process, meaningful opportunity to be heard at a meaningful time. All of these concepts were written again about the Supreme Court in this very case that sent this matter back down on remand. With that said, I have not been served with a copy of this motion. He's responding apparently to my motion that I filed. I mean, I strenuously object to it. I strenuously object to any further proceedings going forward because of the critical part that the Attorney Generals play in this process as advisors. They themselves also, we have argued, and consistent with the Supreme Court's opinion, need to be giving a fair and impartial hearing officer fair and impartial advice. And frankly, I don't even know what these Attorney Generals who I'm challenging through their special attorney, who's a former Attorney General, and who also, I may add, argued before the Third Circuit, before this agency appeal went up to the Hawaii Supreme Court, took an adversarial role as well. He personally appeared for the second hearing that was held before Judge Nakamura and very eloquently convinced the court that it was not a due process violation to put the cart before the horse and grant a CDUP prior to contested case hearings being held. And the Third Circuit ruled in favor of that argument. And they went up to the Hawaii Supreme Court, and the rest is history. But, you know, we also have, we have an individual who also argued an adversarial role, who's now, for some reason, appearing as a special attorney general. I'm assuming to somehow distance himself from conflicts that are being raised by the deputies and also Mr. Chin that this motion concerns. But I think that is also problematic as well. But the fact, really, Judge, is that I haven't been served with this pleading on this critical matter. And I don't know why I haven't been served. I mean, you would think that the parties motion you're opposing would be the first party you serve. But there's no explanation for it, and I ask that these proceedings be suspended with all due respect until this critical issue can be properly addressed with proper service and a proper opportunity to be able to respond to whatever these arguments and authorities that are being raised have been made. Thank you.
I'm going to take document 157 with Mr. Louis out of order, and I invite his argument as well as a response to the concern, a serious concern, that Mr. Wardeman was not served.
Good morning, Your Honor. Thank you for the opportunity. David Louis appearing as a Special Deputy Attorney General. I appreciate Mr. Werdeman's comments, and my understanding was that my office had, in fact, served Mr. Werdeman. Now, I didn't do that. I delegated that to associates and my secretary. So, and this is the first that I've heard that service was not affected. I am certainly willing to have this Mr. Werdeman's motion for disqualification put over, although that's not necessarily my decision, but I don't oppose some short continuance of that until the next hearing that you have, so that Mr. Werdeman can have the opportunity to look at the cases. But having said that, let me just note, since he did argue, I'll just argue very, very briefly that I believe Mr. Werdeman is wrong. The reason why his motion should be denied to disqualify the Department of the Attorney General and Doug Chin and the individual deputies is because he is wrong on the law and he is wrong on the facts. He's wrong on the law because he hasn't followed any of the Hawaii Supreme Court cases, and there's several of them that we have cited in our moving papers. He's also wrong on the facts because the key law is that both the deputies as well as Attorney General Chin as well as myself have always, in this matter, only represented the tribunal, and that is the BLNR. So I don't really want to try and argue these things if Mr. Werdeman feels disadvantaged, and I'm certainly willing to put that over. And I will immediately, this is the first I've heard that service was not affected, but I believed that service had been affected and had been affected properly. Other than that, I would stand on my papers, Your Honor.
Okay, I'm not ignoring you. I'm looking at the document that's in our document library, and I'm particularly focused on the certificate of service. And I think it might have been an oversight, but unless my eyes are failing me, I don't see Mr. Werdeman's name there. So, in fairness to everybody, I'm going to reset this matter for hearing. I'm going to do that. Let's take a 10-minute recess, and I'll tell you what date that's going to be. Most likely, I'm telling you now, it's going to be next Friday. Okay? Let's take a 10-minute recess, please.